So we are on section 7 in remedies, which brings us just about to the midpoint. And so we're going to talk about insurance practice issues, including 176D, which is a Massachusetts statute equivalent to Chapter 93A that we saw in the Pier 4 case. That 176D regulates insurance practices and the like. We're also going to take a look at summary judgment. But scheduled for this Thursday would be your examination before the break. And so that's my question, and I had asked you this before. How many are intending to take the examination in class as opposed to answering all the questions posted by the end of this week? You're going to take an in-class exam? You
by the end of this week.
No. The in-class exam will be Thursday. The alternative is there are a series of questions that were posted online for all the online students, and that those answers, you would submit the answers to those questions on by Monday at midnight on the day you return from spring break, which must be, I think, the 18th, right? So that's the question. If you either you will take the exam and be graded, just a regular in-class exam and be graded on that, or you have the take-home alternative. So.
Take home, all right.
Well, you can all do what you want. Okay, so you're the only one going to take the exam?
I'll take it home too. I don't want to be the only one.
Okay, so you just look at the questions, make sure they're all answered by midnight on the Monday when you return from spring break. And for the online people, those answers are all due. They should be being filed within the week of the second class for each section, but everyone's questions, the answers for those questions are due on the Monday when we return from spring break by midnight on that Monday. So 11:59 that night on the Monday when we return, which is March 18th. All of the answers are in, everything should be up to date. Okay, so we're all on the same page? And let's talk about the Rule 56, the summary judgment, which is on the agenda for today with respect to taking a little closer look at the rule before we get to some of the insurance cases that we want to look at. Certainly every major civil case I've ever been involved in, virtually without exception, there's always going to be a summary judgment motion before we get sort of green lighted to trial. Summary judgment motions are what I call the third of our three testing motions, or the second. Motion to dismiss tests the complaint. Motion for summary judgment tests everything assembled up until the time the motion for summary judgment is filed. Tests to see whether there are material facts in dispute that rise to a triable level. And if there are not, then the argument is that the moving party is entitled to judgment as a matter of law. Since there are no material facts to resolve, the court is free to determine how the law applies and issue summary judgment accordingly. So it tests to see, in essence, whether the case is jury worthy. Now, whether you're in federal court or state court, Rule 56 is used in almost all civil cases, either for to eliminate all of the claims or to eliminate some of the counts within the complaint. And you will move with the motion and likely affidavits to show the absence of the material fact in dispute. There's also generally a memorandum of law that's going to be filed along with it. And what you're going to find, whether you're in federal court or state court, is that the process generally now, through the rules of the specific court itself, Superior Court rules or the federal court local rules, will generally require you, in addition to filing your motion, your affidavit, and a memo, to also assemble what the facts actually are in what sometimes is referred to as a combined statement of facts. these are the facts that are not in dispute, and to the extent that you are the opposing party, you would have to show why that isn't accurate and point out the facts that you say are disputed within that, and not just say that they're disputed, but point to evidence in the record by way of deposition or exhibit or something along those lines where you could say that that fact is not only controverted, here's the proof of the alternative, and this is what, if we're allowed to go to trial, we will produce. What that means is it's an incredibly labor-intensive process in any case of any significant size, and so summary judgment really becomes a pretrial device to assemble where we stand. What facts are we able to prove at this point? What facts are legitimately in dispute? Not just claiming they're in dispute, but what evidence do you have to show it? And it gives the court and you and your adversary a chance to really examine the strength and weakness of the case. And again, remember, at least in part, summary judgment is in the court's interest as well, because to the extent they grant summary judgment, you're not consuming vast amounts of their trial time, and so the court is freer to be able to clear up its docket and to proceed at a quicker pace. Even if you have a trial that's going to take just a week, that means that a lot of the other court business that judge may have will have to wait till the following week or the week after that or whatever. But what it means is that the whole process then is significantly delayed. So the more modern rule requires you, through these combined statements of facts or agreed upon facts, and then references in the record to where legitimately you dispute the facts and where the proof of that is, it can be an incredibly labor-intensive process. It usually is in any case of any significant size. And oftentimes the defendants also file it, but the plaintiffs file it as well. It's an effort to slow down the process again, because sometimes summary judgment motion and all the attachments and all the supporting material, it might be anywhere from 3 inches to a foot worth of paper. Well, that means the court has to read it, has to really digest it, try to examine it, and that could take months. And again, to the extent that it takes months, the plaintiff is that much further from getting their trial date and getting squared away. So summary judgment is frequently used in civil litigation, very few cases where it isn't. To the extent that you can successfully keep it moving to trial such that perhaps it's clearer that summary judgment is inappropriate, you might find a defendant or a plaintiff who forgoes it because of the clear dispute of material facts. But if I were defending a case, and as a plaintiff, by the way, as a general matter, I tend to favor jury trials. So I might file a motion for summary judgment as a protective matter, expecting that you're going to file one. But a lot of times I'd be a little leery, unless I've got a really clear case on liability, I'd be a little leery taking it out of the hands of the jury potentially, and because in essence we're saying to the judge, you can decide this because it's only a question of law. I would still prefer, as a general matter, that the jury determine the scope of the damages. I think they're oftentimes a little more generous than some trial courts. And I think defendants fear what a jury might actually do with the case, and that risk of a large jury verdict oftentimes brings them to the table a little more aggressively with respect to settlement. So as a plaintiff, I don't use it that much unless it's a clear case on liability, and then I would move for summary judgment as to liability only. And if there is, as a defendant, I would almost, if I were representing defendants, I'd almost always use it because it both, there's nothing to lose if it's granted, and at the minimum, it's gonna slow the whole process down. Sometimes courts, the judges will sit on summary judgment motions for ages. And the court is not likely oftentimes going to set aside trial time if there's a summary judgment motion pending. And so that can really sort of mess up the whole works with respect to your schedule with respect to trial. Usually the court's not even gonna set trial dates at all until dispositive motions have been heard and resolved. And the resolved, we don't control. I can control when I file it, I can control when the court receives it. I don't control then how long you're gonna take to act on it. And so, summary judgment is crucially important in civil cases, and it can be an incredibly expensive process as well. And that's the other thing, the last part of it, is that, you know, to the extent that the defendant files it, and has put in all this work, they've now made a ton more money, which is in the lawyer's interest anyway. And oftentimes defendants don't want to address the settlement or resolution of the matter until this card is no longer in their arsenal. So sometimes we have to get past this just to have some meaningful discussion, because if you're able to defeat the defendant's summary judgment motion, then what that means is there's nothing left here between us and trial. It may be time to get very serious about whether you intend to try it or whether you're going to make an offer such that it makes sense for me to walk away. So a lot of times the whole mediation and the real attempt to resolve it oftentimes won't come till summary judgment is off the table. And that's pretty deep into the process at that point. Pretty deep into the process also means the defendant's attorneys likely have maximized their fees. And it may be, now it's put up a shut-up time because we're going to trial and we're going to impanel a jury otherwise. So summary judgment is a vitally crucial step in the whole civil litigation process. You guys have questions on summary judgment? Yep.
You mentioned that, you know, a plaintiff can, let me rephrase. Now we have multiple claims. You have a negligence claim, you have a discrimination claim, and you mentioned that you can move for a summary judgment on just one of the claims.
Yep, think of them as counts simply because in a complaint, each claim or each count is set off separately. So that, you know, I want to recover. I sometimes think a claim, this is my claim for damages, but they may have different legal basis to get to the same point about I want to be compensated for my loss. And so each count generally will advance a distinct legal theory.
Now, what if those counts kind of commingle with each other, so to speak?
Well, the counts will, because oftentimes in the complaint, what we're alleging are the same facts to support almost all of the various counts. But as you said, okay, I have one count. Let's take something kind of typical. I have one count that's a breach of an employment contract. Whatever I'm saying, it's a breach of contract. I have another, and that's a separate contract based on a separate count, separate claim, based on whatever the law is with respect to that breach of contract. I have another count separately in the complaint about discrimination, right? And so within my employment, I feel that they have discriminated against me and exposed me to a hostile work environment. That's maybe two separate counts. One discrimination, one exposure to a hostile work environment. That's it. We got 1, 2, 3 so far. Fourth count is a separate federal claim saying that you have failed to accommodate me under the Americans with Disability Act, and so therefore I've been damaged. So now it's all the same. I've been fired from my job, but now I've got 4 different legal bases, legal theories that would support my recovery. And it wouldn't take long to actually add a couple more of them in here, okay? Maybe, well, frankly, it's the situation I'm describing, or at least as you can infer from the counts I'm describing, I'd probably throw in an intentional infliction of emotional distress. That's oftentimes coupled with these because some of the, and actually I had one, not only we had that, and then we also had a false imprisonment count, because they brought him into the manager's office. They wouldn't let him leave until they were trying to force him to sign a document. He was having panic attacks while he's stuck in this little room. And so we sued we added an account in for false imprisonment as well. So it's all based on this employment relationship that went really, really bad. But he's got 6 different legal theories as to why he should be recovering for his damages. When the defendant moves for summary judgment, they might argue, well, let's take one, and they might easily argue, okay, the contract action is a 6-year statute of limitation. The tort claims, false imprisonment, emotional distress are 3. The discrimination are 300 days. So let's say they move for summary judgment on the discrimination claim and the hostile work environment, which would be 300 days too, arguing you didn't file these timely. Because you didn't file those timely, those 2 counts, we should be granted summary judgment because we've shown you knew about these injuries on such and such a date, and it's uncontested you didn't file suit till 2 years after that date. That's a pretty good summary judgment argument, because even though there's still a lot of facts out there that are disputed and disputable, the material facts on that count are when did you know you were injured in this fashion, and when did you file suit? And filing suit, that's a given. There's no disputing what that date is. That's going to be when that complaint was entered, right? And so the only other thing is when did you know? And if you've got deposition testimony or other information that he knew on such, on or about such and such a date, and he's way past that date, that summary judgment as to at least those 2 counts, which would then reduce the potential theories that you submit to the jury, and any damages solely under those, like double damages or punitive damages for the discrimination claim. And it reduces the defendant's exposure potentially. And if you think about it, the one I just described to you, or at least on the statute of limitations, is a relatively easy procedure, but they did it on a whole range of, they wanted to try and get rid of the whole claim in its entirety. So seriously, the summary judgment pleadings, the submission in that case, and that's pretty accurate about what that case, the counts that case contained. The summary judgment material was probably at least 1.5 feet. It was an incredibly time-consuming and expensive endeavor, and the defendant wasn't going to come to the table till that was resolved anyway. So they were taking their shot to try and dump the entirety of the claim. And until we do, we're not making any money either.
Yeah,
Yep.
so, quick one. So a claim that has been subjected to the summary judgment procedure, I mean, we did a pre-trial.
Yes.
So in that case, assuming a summary judgment is given to any of the
Oh, it's granted?
Exactly.
Okay.
It's granted. So because we have not gone to trial, is there any possibility that I can just go back and amend my pleadings and then come back?
I don't think you're going to be able to amend your pleadings on summary judgment. You could have amended it prior to it being granted. But once it's granted, then your challenge is to take it on appeal if you think it was an error. And if you think that there are mistakes, you have free to amend it during summary judgment if the court grants it, because once the pleadings are closed, you're going to need the court's permission to amend your pleadings. But once it's been granted, you're likely going to be out. And whether it's tried or judgment is granted by way of summary judgment, it's still going to be preclusive. You're not going to be able to go back and file that suit again. Okay? Questions?
And just on that, just for clarification, I'm just trying to map it all in my head.
Yep.
In a situation like that, it's granted, you think there's an error, you move for an interlocutory appeal?
it's not an interlocutory appeal. If summary judgment is granted, it's a final order.
Well, I'm saying
If,
if
oh,
you wanna
granted
change-
as to 2 of the 6 counts?
Right, two.
No,
Okay.
no, no, there's no reason to appeal it at that point, because it's still an interlocutory order, because it doesn't adjudicate the entirety of the claims, okay? What you could do is move for separate judgment, under Rule 58 for the 2 counts where summary judgment's been granted. And if the court grants that, then take your appeal on those counts, but you're still in the trial court on the remaining 4. And as a general matter, the court would prefer you wait till those claims are resolved, because frankly, if we win on any one of the other, if I'm the plaintiff and I win on any one of the other 4, I'm not likely going to appeal the 2 I lost on. Unless one of those counts the discrimination claim, I might, and if it was a 93A claim, I might. Why? Because they would award both attorney's fees and a multiplier for damages, and the discrimination might even include punitive damages. So I might appeal that, but I've told you before, I'd be cautious with that because pigs get slaughtered. I don't want to appeal, then they will take a cross appeal from my appeal, challenging even on the ones I won. I'm not so sure that's worth the risk if I've got enough money under the other counts to justify it. So you gotta, you gotta be careful with that, because you always can take a protective appeal if they appeal first. But if I had a strong 93A or the discrimination claim, I'd be careful before I just let that go, even if the court granted summary judgment, because of the attorney's fees that are due if it goes to judgment. But by the way, so what that means is, so court says, nope, you were wrong to grant summary judgment. Okay, back to where we started, and that means we still have to try those counts. And so you've got a mess on your hand as well. I still wouldn't let them go if I thought that they were strong counts and that the court was in error. But, the benefit of the doubt is going to go to the trial court as a general matter, not you. You are talking about a pretty expensive process to pursue it through appeals as well. You've got to be careful with that. I know we tend to think in law school, so if you lose in the trial court, you take it on appeal. You lose there, you take it to the next level. I don't think that's realistic. I think a lot of times I've lost some in the trial court, and that's where they die. Because at some point you got to listen. Maybe the judges aren't always wrong, or the juries aren't always wrong. Especially juries is even less chance of appeal unless there's been bad instructions or other procedural flaws with respect to evidence and the like along the way. A lot of times, you want to win in the appeals court, win it in the trial court, and then you can hold that line. But you lose in the trial court, chances of being overturned on appeal are relatively low. I think I've told you that before. I think that statistically it's about 15-20%. It's small. And I think it's shrinking every day, again, because of people want to do less work, not more, and that includes a lot of judges.
At what point did this civil procedure spider web sink into your brain? 'Cause I try to,
I think the more you talk about it and work with, listen, I've done this since I was in college. So, and I practiced law longer than some of you have been alive, right? So, to me, it's second nature at this point. But some of it is, and especially, and this is why I like to stress the rules here. If you're going to do this, if you intend to do litigation, civil or criminal, it's like a card game. You got to know the rules, right? If you play cards without knowing the rules, you might as well just throw your money into the pot and walk home, because you're not going to be winning. And so both litigation is heavily rule-based, whether it's the rules of civil procedure or the rules of evidence. And I mean, I've worked honestly. Like 40 years now. I know, feeling old saying it. But I did it all through I did it actually. I started in a litigation firm while I was still in high school, and so some of it, a lot of it comes a lot easier. But But the more you do, the more you're familiar with it. And, you know, that's the other thing, is the other part of that is knowing the rules well. When you are challenged, then you are able to reply and the rest of it. And you learn, you should be, I'm hoping, I'm trying to explain to you, you need to learn the intricacies of it, because there's a lot of people that will be pushing you around and doing stuff because they think they can. I got one now still. It should have been resolved already, and seriously, and I've dealt with a lot of big jerks in the course of my career. This clown takes the cake. And so you just have to push back just as hard. Professionally, civilly, stay up here, right? They go low, you go high. Well, it's a challenge, but the fact is that otherwise you don't accomplish anything when you do ultimately go to court. The court just sees a couple of bickering lawyers. If they're not complying with the rules, then you've got to call them on it. You've got to insist that that's what's done. And at some point, it does, you know, become clearer. The path becomes clearer. And especially part of it is the experience, knowing exactly what to expect and why they're doing certain things. Because a lot of times, what still doesn't make sense to me after all this time, except I understand the reason, is that there are a lot of cases where it would be in the defendant's interest to engage in serious discussions about trying to resolve it far sooner than it happens. But it almost always happens after summary judgment is disposed of, and truly within 30 days of trial, and sometimes within days of trial. And is it, I mean, this is very cynical, is it just because at that point the defendant's lawyers have maximized their own fees in the case, and now it's just a lot more hard work and risk to actually call your witnesses, put your evidence in, assemble all that stuff, and actually go forward? And I do think that is part of the reason, because and frankly, I don't see where it makes sense a lot of times, because that number. Because when I know I've defeated you at summary judgment, I know we're moving forward, and I can really take a look at the extent of all my evidence and figure and assess the likelihood of success. My number's gone up, and sometimes not insignificantly. And part of that is because I think that now I got you, right? Now I understand how this likely plays out. I've got the questions going to be submitted to the jury the way I think maximizes my chance of recovery. You know, before summary judgment, maybe I would have thought, you know, looking, this judge leans towards summary judgment. This could be a challenge to get past. Maybe that would have been a much better time, because once I get past summary judgment, now there's nothing barring me to what I know you likely fear most, which is putting this case in the hands of a jury that could run away and bring back a much bigger number. Now, with that said, this is the last word on that, juries are a lot more conservative than people think. You know, I mean, you hear the excess verdicts and people rail against them. Juries can come back and say no. Juries can come back and lowball numbers. They don't just throw money like the insurance companies and, you know, some defendants complain. They are pretty discerning with respect to the judgments they render. So I don't want to convey to you that, you know, the jury is just an open checkbook for you. It isn't. You still have to convince them of the strength of the case. And they have to feel for your client and want to do right by them. But they don't just throw money at a problem, as some people think. There's a lot of verdicts that come in cases that are tried that are for the defendant or for relatively modest amounts. So don't think that you want to try every case. You got to value them reasonably with the expectation and thought about it. You know what was interesting is when we were in Connecticut, what they actually do down there, and they have a horrible trial process. The impaneling of the jury alone can take, seriously, weeks, because everyone gets to question each potential juror separately. It's just a god-awful, expensive process. They actually will list, they not just list, they have copies of the jury verdicts that were returned that week. It's right at the clerk's office. You can just grab them and take a look. A lot of times, and I don't know why other courts don't do the same, because it gives you a better assessment as to what's happening in that community, what that jury is likely to do with cases that might be similar, or at least, you know, what types of numbers are they putting on any case, because that's helpful to know. But in Connecticut, in the Superior Court, they have a little sheet, and you can look at it for each week, and not just look, they give you copies. Because I was taking a picture with my phone, because I thought it was kind of secret, or I don't know what I was doing there, but I figured I didn't know I could take it. And so I'm taking pictures with my phone of the various lists, and she said, aren't there any more copies left? And I said, oh, no. I said, there were, I didn't know. She said, oh, take them. And so other courts, it's very difficult to get that information. So again, the more information you have, the more helpful it is to try and make valuations and what you think the jury is likely to do in that community, because that becomes important, obviously. Let's talk about Timpson versus Transamerica, which is a case for 176D. It also brings up the classic agency principle as well. And I hope you read it, because I just always like this case, because it reinforces some basic principles of agency that you should be familiar with and be able to explain. And it also introduces us to this insurance company's obligation to their insured and the like. And let's see, this action was commenced in 1993, and the action took place in 1991, and this case involves the world champion Patriots football team, back when they were not so championship-like. And it's an interesting set of facts, and it was obviously a pretty big to-do then, probably be even more these days. But Michael Timpson and some of his professional football teammates were not crazy about the female reporter from the Herald being in their locker room. And what they did while Ms. Olson was present in the room is that she was conducting an interview with Maurice Hurst. During that interview, another player, Zeke Mowat, who was naked in the locker room, started standing very close to Olson, making crude remarks and gestures towards her. Timpson laughed and shouted encouragement to Mowat. Other naked players approached her, displaying their genitals to her, and made vulgar comments. A member of the Pats management was there and did nothing. Ms. Olson ultimately sues the Patriots and these individuals for what I would describe as a sex assault, and what I think today they would have likely faced criminal charges for. Perhaps should have done it at the time. And so she sues them. The Transamerica Insurance Company insures the Patriots, and Michael Timpson wants his $87,000 back that he paid lawyers to defend him in this matter. And so Transamerica said Timpson's conduct was outside the scope of his duties as a Patriots employee, and therefore he's not covered under the policy. Whatever expenses he has are his own. And so Timpson wants to argue that he was within the scope of his employment at the time that he's shouting encouragement to his fellow football players who were engaging with Ms. Olson. And so first, part of it's a summary judgment case too, and just the language on 346. In reviewing a grant for summary judgment, we determine, and this is the standard, whether viewing the evidence in the light most favorable to the non-moving party, all material facts have been established, and the moving party is entitled to judgment as a matter of law. So the first part of that to think about is the benefit of the doubt goes to the non-moving party, right? And view that in the light most favorable to the non-moving party. It is the moving party's obligation to show the absence of any material facts in dispute. And so, first, I want to take it from the standpoint of, was Timpson within the scope or course of his duties at the time that he undertook this activity? So I guess we need to look at in Massachusetts, and the law is pretty similar elsewhere, but in Massachusetts we have what we call the Wang test. And so what is that test to determine whether an employee is acting inside the scope of his employment and thus the employer is responsible for his acts, or on the contrary, the employee is not working for the benefit of the master but is on a frolic instead? What's the test? Three-part test.
The conduct of the kind he is employed to perform.
Okay, 1, the conduct is of the kind he is employed to perform. 2,
It occurs substantially within authorized time and space limits.
it occurs substantially within authorized time and space limits. And 3,
It is motivated, at least in part, by a purpose to serve the employer.
okay, that's the test for an agent to see whether the agent is acting within the scope of his employment. So let's unpack that a little bit. The conduct is of the kind he is employed to perform. He says he is. He is required to engage with sports reporters, and therefore, because he is, that's what he was doing, and he should be okay. What do you think of Mr. Timpson's argument there? The conduct is of the kind he is employed to perform, and the others as well. Pushing their genitals in her face sounds like the conduct is of the kind he is employed to perform.
Well, I mean, the argument could be made if in the sports arena, that is the kind of conduct that journalists within the same setting.
Which part?
I mean,
The
like,
first part that I've got to engage with reporters, because I don't think you have to engage them in that fashion.
Well, I think in the sports industry, most local rooms to this end sometimes got invaded by journalists, and people don't really see it to be offensive because maybe perhaps that is the norm.
Well, what about that? She's in the male locker room. Football players have a screw loose anyway, right? Should she expect that they will behave appropriately at all times, or do we cut him some slack and say we can't expect you to behave so appropriately that you're employed to perform this conduct, although I don't believe the Crafts would want you performing it in this fashion. Let's take a look at 2. It occurs substantially within authorized time and space limits. You okay on that? It's in the locker room. It's after practice. He's in the right place, and he's during the right time. He's okay on 2, right? And 3, it is motivated, at least in part, by a purpose to serve the employer. No? Is he better off on 3 or 1? Because I could argue for 3 for him. Team unity, right? Team bonding. We're all getting together and we're having fun at someone else's expense. Don't you think that has? I think he actually advances that. He thought that this would help promote team because we're all doing this lousy thing to this female reporter. No? Zach says he thinks he's closer on 1 than 3. So what was his motivation, do you think? It says it is motivated at least in part by a purpose to serve the employer. If, however, an employee acts from purely personal motives, in no way connected with the employer's interest, he is not acting within the scope of his employment. Is that just that they want these female reporters out of the locker room, not invading their space? Purely personal motives? He says he was engaged in some Patriots team business, changing his clothing after the game. So I don't think they quarrel with 2. Timpson also contends that he meets Part 3 of the Wang test because he was motivated in part by a purpose to serve his employer. And let me ask you about that, bottom of page 348. How is this different than Manning versus Grimsley? You see that case on the bottom? It says he's relying on Manning versus Grimsley, a professional baseball pitcher who intentionally threw a baseball toward hecklers and injured a spectator was found to have acted within the scope of employment because heckler was interfering with ability to perform, and thus quieting the heckler would result in better performance by himself and team. Imagine that. He throws a fastball at some person in the stands, professional baseball pitcher, and they say, yeah, that go team. Is it really that different?
Well, I think because the baseball player was on the mound at the time.
Huh?
If the pitcher threw it at somebody that is safe to infer that he was on the mound at the time, so he was technically still within his.
Well, but he's in the right place. You guys said he's in the locker room.
No, he's in the right place, but I don't think, him undressing and, lashing his private parts to a reporter is conduct that's acceptable.
Well, I don't think it's acceptable, but look at what he goes on to say. It says he, like the baseball player in Manning, was acting to promote better performance of the team, right? He explains that by laughing and shouting encouraging words to his male teammates, all of whom were allegedly sexually harassing a female reporter, Timpson was promoting team unity. This is not... What?
Baseball, when he's silencing a critic, I can see how that would bring the team together. Like, screw that guy, what he's saying, let's play better, not shaking our wang test.
Yeah, you like that, huh?
Like, that's funny, and it makes people laugh. I still don't see how that brings people together. Like, when they're in the huddle out in the field, they're like, hey, remember that? Like, let's make this play now.
Well, I think if you do put it, and I hear that, and I think that's where the court ultimately goes, but I think in part, they really didn't want she was one of the first female reporters in the locker room. And they didn't want them there. They would fight for times with the male reporters. This was Maurice Hurst. Raymond Claiborne one time punched a Globe reporter in the face because he didn't like them either. So, I think they didn't like a lot of the reporters in the locker room, period, but especially I think they believed that the women were interfering with them to a greater extent. But you're going to cover what I would, if you did this type of activity in the law school or in wherever you may work, you'd be let out in cuffs, right? And just because it's in a locker room, you now want to cover it as part of your job duties that the owner is responsible for? So are you all comfortable though then? Because if he's not within the scope of his employment, Transamerica doesn't have to cover him at all, and he loses, he's on the hook for these claims. And he's out under those circumstances. Right? So we're all good with that? You don't have a problem, and you do see an ability to distinguish it between Manning and Grimsley in this case. Because one of the things they raise here is not only is he not then covered for whatever he does under the insurance policy, but the insurance company then has no obligation to defend him either. As a general matter, when you're insured like this, so there's a policy of insurance, not only do they have to make a reasonable settlement offer once liability is clear, they also have an obligation to defend the insured under the insurance policy. And he's saying, well, you didn't defend me, I had to go get my own counsel. And so they're saying, well, we didn't defend you because we didn't have to, because you were outside the scope of your employment. And therefore, you're not covered under the circumstances, and we were right. Sometimes, by the way, they will defend you for the case, but under what we call a reservation of rights. They'll say, okay, we're going to defend you, but if the facts become clear at some point that you are not within the scope of your authority, but outside, then we're not gonna continue to represent you, and we are not agreeing simply by going forward and representing you that we're gonna cover any risk associated here if it's later determined that you're not within the scope of your agency. So there's all sorts of things going on here that he has to try to get past. But at the end of the day, he's having real trouble trying to show that he's within the scope, of course, of his duties. I don't see it as clearly as you, trying to distinguish it from Manning versus Grimsley. And how is throwing a baseball by a professional player at a fan something that the conduct is of the kind he is employed to perform? No, it's not. No, you're supposed to throw it at the plate, not at people in the stands. So to me, Grimsley's got the same problem as Timpson, at least with respect to one. I'll give you two. And I don't know whether Grimsley has the same problem in three. It is motivated at least in part by a purpose to serve the employer. No, you're mad. You're mad that the person's doing this, and you just want to hurt them. That doesn't help me sell tickets. I think I have trouble with Grimsley, and I think the problem is that if you're going to cover Grimsley, I don't know how much further Timpson is. But I hear you, and I think you're probably right. It's just I think it's a lot closer of a distinction, simply because this was so distasteful what these guys did. It's almost amazing that he would have the chutzpah to come in and say, no, I was in the scope, of course, of my duties. Because hassling a reporter in this fashion and bringing scorn to the Patriots, which we had an ample opportunity and ample reason for people to scorn us then. He's not likely going to find that this type of conduct could be covered as being an agent within the scope, of course, of his duties. So let me ask you, thinking about this. So you work for Kentucky Fried Chicken, and your slimy boss is sexually harassing you and tells you that if you don't sleep with me, there'll be no promotion, no overtime, no money to pay your bills, or no extra money. You can keep working here, but... And he means it. Well, she means it. Doesn't make a difference which gender you want them to use. Kentucky Fried Chicken isn't responsible for those acts, at least under an agency relationship?
I think it's going to depend if there's been a history of that.
Well, we're not going to say that at least we don't have any history right now. You have the facts that I've told you. So 1, 2, and 3. You're out, right? The conduct is of the kind he is employed to perform. You are not employed to hassle junior staff. Number 2, I guess you're okay on, right? It's still in the store and yada, yada, yada. You're okay on 2, just like Timpson was. Is motivated at least in part by a purpose to serve the employer. You're out on that as well, right? So it's not going to be an agency relationship that you establish liability on under those circumstances, right? I mean, just being consistent. We want to tag Kentucky Fried for the damages here, but it's not going to be under an agency relationship using the same test. We use this test no matter what. This is the test for agents. To make the principal responsible for the acts of the agent, it's this 3-part test. And you got to get it down. The conduct is of the kind he is employed to perform. It occurs substantially within authorized time and space limits. And 3, and this is what's interesting about 3, it says it is motivated. And to me, and then it says, comma, at least in part. And that's the key, at least in part, right? We might, and even sometimes when it's misdirected, but at least in part. It doesn't have to be purely motivated to serve the master. But if it's motivated, at least in part, to serve their interests, and you've got the other two, then you're okay. But, maybe somehow this person thinks that, well, this promotes, that this is good for morale, or I don't even see how you could say that. I'm not sure what the argument would be, but you're going to fail on one almost invariably under the circumstances I described to you anyway. No one employs you to perform what you're asking these folks to do. So I think you got to think about where this goes then with some of these other cases as you start to see it. And the reason we took off the history aspect of it is that if you have a history of it, then it's a negligent supervision and a hostile work environment claims. But it's not an agency claim, right? Then they're responsible because they failed to properly supervise, or they should have known there was a hostile work environment. At the end of the day, you're responsible for the hostile work environment that you expose your employees to. So, to me, Timpson is a good case to start to think about some of these issues with respect to insureds, insurance companies, and their obligations to each other. And Timpson advanced a couple claims here that I want to conclude with, one of which is 176D. 176D is the Massachusetts statute that is equivalent to Chapter 93A, but it regulates insurance practices. So 176D will keep the insurance company honest. 93A, as we've seen before, like 176D, awards damages and a multiplier for damages as well as attorney's fees. So a lot of times we'll use those two statutes in tandem when we're dealing with insurance carriers, but they are important ones for you to start to understand, especially with insurance carriers, that there's a pretty significant amount of consumer and business protection found under 176D for when you're dealing with insurance companies. So be mindful of that. 176D provides a lot of benefits, and we will often invoke it when we're litigating with insurance companies. Let's talk about Branley versus Fidelity Guarantee. And so this, to me, again, now this is an interesting case. A lot of cases with insurance carriers or other defendants start with a demand letter laying out what the damages are and expecting some response at some point to that demand to at least begin or to move forward with the dialogue. And so what happened here, and I know the plaintiff's lawyer, I actually used to litigate against him quite frequently when I was first a lawyer. I know the judge that wrote the decision had an interesting experience with him as well. But the Branleys were hurt when they were driving down in Plainville, and they tried to work it out with U.S. Fidelity and Guarantee, the insurer of the other driver's employer, and they made a demand on April 29th, 1988 against Fidelity, and Fidelity made no response at all, which is a mistake. Ultimately, 1990, so November 89, almost a year later, they made a settlement offer of $7,500 on Paul's claims, $18,000 on Gail's claims, but they are required under the 93A letter to respond within 30 days, and this is well past that. Ultimately, these claims were settled for $84,000 on the first day of trial. As I told you, there's a lot of defendants, that's what they wait for. Sometimes you're bringing the first jurors down and they finally say, okay, they stop the game of chicken. Other times you're making calls 10 o'clock at night before you're going to trial, because some people like to play brinksmanship. I'm not sure that'll ever change. It's too bad, but that's the nature of the beast. And that's the other thing about knowing your rules, both civil procedure, criminal law if you're trying criminal cases, and your evidentiary rules. You know, the fact is you should not be scared about taking the case to trial. You're going to know your facts well by that point. If you know your rules well, then the likelihood is you will have a superior advantage in the courtroom. So, you know, to me, it's often like all the physical activities that you practice for, and by the time the game comes, between muscle memory and just knowing that at the end of this it's over, the easiest part is playing the game. The hard work is all the prep that went into that. And that's the way you want to think about it. Don't worry about, oh, I'm nervous. Of course you're going to be nervous. You're going to be nervous for the rest of your life if this is the work you do, because shortly you've got a final exam and people are coming back with a real decision in real time that's going to tell you how you did. You'd be foolish not to be, but that doesn't mean that you can't execute it well. Again, if you know your stuff and are properly prepared, and that's the work you put into it. That's all the practice. But at any rate, so this was settled on the first day of trial, in the morning of the first day, for $84,000. And then what happened is that there were a second series of litigations involving the 176D and the 93A. 176D was Unfair Claims Settlement Practices Act that they invoked, saying that they did not respond as required under 176D, and therefore they have liability under those circumstances. And they cite three things they didn't do. They failed to acknowledge and act reasonably promptly upon that communication that the plaintiff sent on the demand letter. 2, they failed to effectuate a prompt, fair, and equitable settlement of that claim when liability has become reasonably clear, because they litigated this for some time. And 3, they compelled the insured to institute litigation to recover amounts due under the policy, offering substantially less than the amounts ultimately recovered in actions brought by such insured. So they invoked both 93A and 176D, and their failure to respond to the demand letter is really a significant problem that they don't have an answer for. But let's talk about a few of the points that are made. Again, we've got a lot of summary judgment stuff here, but you have the basic understanding of what's gone on here. First of all, the attorney's demand. Hans's demand, asked for, was it $1 million plus? I'm just trying to look at the number here. I don't know where it went. Here it is. His initial demand, plaintiff's counsel forwarded a 93A demand for $990,000, $10,000 shy of $1 million. And the insurance company got it, and for whatever reason, I think they said, well, there's no reason to even have a dialogue here. That's a ridiculous amount of money. If you look at that in relationship to what he ultimately settled for, it is a ridiculous demand under the circumstances. But what he's saying is, listen, 176D doesn't regulate my behavior as an attorney for the injured party. It regulates the insurance company's behavior, and regardless of whether they think it's ridiculous or not, they have an obligation under the statute to respond. And he's right, and that court says he's right. Yeah, is it as appropriate as it should have been? The answer is no. He could have made a more reasonable demand, but the fact is that his behavior, the attorney's behavior, is not governed by 176D. The fact that they ultimately settled for pennies on the dollar compared to that, it was really like less than 10% of the initial demand, because one of them is over $1 million. 1.4 million was Paul's, had an additional $50,000 claim for loss of consortium. The fact is that you don't judge it by the silliness of the initial demand. You judge it by what they did and under what circumstances. They were not reasonable in trying to come to a compromise on this, the insurance company, and they're the only ones that have to be reasonable under the circumstances. It's kind of silly when you look at the numbers as to what the demand was and where they ultimately went, but Fidelity was trying to lowball it. He was obviously trying to be ridiculously excessive, and again, unfortunately, sometimes that's the way the dance goes. To me, it's kind of silly if your claim isn't worth anywhere near $1 million to make $1 million demand, because even if they do respond, it's not going to be a dialogue that's likely to be productive. But you would be amazed how often sometimes, one side, the defendant, stays at a $5,000 or $10,000 figure, even when you're at a legitimate $600,000, $700,000, $800,000 figure. You're not offering me an incentive to come to the table and really have a serious dialogue. Put a serious number on, and we can see if there is a middle ground there. But unfortunately, we still do this dance in a very outdated and inefficient method of negotiation. We both lie about what it is we're really looking for. And until you get someone that can really start to make an assessment and isn't afraid to have a serious dialogue about the value of the case, bullshit like this still happens. So ultimately he takes, does he take less than 100 or just around 100, which is 10 cents on a dollar from his initial demand. The bottom line at the end of the day is that it doesn't matter. The insurance company has an obligation to act appropriately, and their practices are regulated by statute. Having not done so, the fact is that they are responsible under the circumstances for the violations of 176D. The fact is that they are then responsible and liable because of their failure to act promptly upon that demand, to respond to it, and to make an appropriate offer of settlement once liability has become reasonably clear. It's a significant tool in your arsenal to invoke 176D. I want to mention one thing is that I have this case in here, and then you'll note there's a little quick slip opinion from the court as well. After this case was tried, after this decision came in, they then obviously settled the case and then went back to the trial court to vacate this decision, to in essence expunge it. And so what the court ultimately did is vacate it and withdrew it as a condition of whatever settlement they reached. The reason I've added it in here is that there's a lot of cases that says 176D protects the insured, not people who have done business or been injured by the insured. This is one of the few cases where it's the adversary, the person that didn't procure the insurance policy, that now wants to take advantage and invoke 176D. So I put it in here so you can see that it might help under those circumstances. What sometimes happens in a case like this, where the insurance company has acted irresponsibly during the initial case, is that the plaintiff will settle with the defendant for whatever they can agree to and what the insurance policy may be under the circumstances, and get an assignment of any claims they have against their insurance company for violations of 176D. So in essence, they assign that claim to their adversary. Under those circumstances, the adversary has a cleaner situation about being able to come after the insurance company for the defendant, because the insurance company is going to argue that they're not in privity of contract with that other person. You didn't pay for this insurance. You're not a beneficiary. You're like Timpson. You're a stranger to this contract unless you are insured under it or an agent of an insured. You're none of that. You happen to be the person injured. So sometimes that's how you'll settle, and you'll get an assignment of their claims against the insurance company and then be able to proceed with there. Lastly, I want to just mention Judge Mazzoni quickly, because I just had an interesting experience that I want to express to you, because I think it's your obligation on behalf of your client. Judge Mazzoni was about 6'9", big, huge former hockey player, and really like towering and broad. And we had a mediation with him one time, in a pretty significant case. I had a mediation with him. And I had a good client who would listen, and at some point throughout the day, the mediation went on quite long, they still weren't at a number that was appropriate, because I could win, we could easily, not easily, but the likelihood is we had a good trial judge, we had strong jury questions that we had already been approved, we had solid evidence that the defendant not only did what we said he did, but has fabricated and altered evidence to support that, and I could prove that as well. And at this point, we weren't going to walk away for anything less than significant money. It was a very important and profitable product that had been stolen from my client. And at some point during the day, he just wants to be done, and he wants my client to take whatever. Well, it wasn't insignificant, but it wasn't the right number, and so he says to me, you know, hey, have you ever seen back here? We're in federal court. Have you ever seen back here behind the bench and all? He said, let's take a breather and I'll show you. And he was just talking to counsel, me and the other lawyer. So I said, sure. Well, I mean, that's what the judge wants to do. What the hell? But that's not what he wanted. He wanted to take me in the back room, and he wanted to lean over my table and yell at me. And this is what he said. He said, the only thing standing between this case and a deal is you. And he said, and you're going to go back out to that room, and you're going to tell your client to settle. And my point is not to tell you, not to the story, not. You got to be prepared to fight back for your client, right? I mean, we don't have to fight. I don't have to raise my voice. We don't have to be unprofessional. But frankly, I thought this was incredibly unprofessional. But you have to say, I appreciate what you have to say, but that's not going to happen. They're not at a number that makes sense for me to be able to recommend to him that this is the best deal he can get. And you have to do that because he would have listened, whatever I said, because that's why the judge clearly said, what do you think, Mike? I said, no, we're not, no. He would ask me, no, that's not the number. I've told you all along that's not the number. And we're not just walking out of here. We invested a lot of time and a lot of money in the case. It was worth a fortune. I mean, a fortune. They had invented, the two of them together, had invented a cardiac catheter device that was then ultimately sold to a surgical electronics company that I don't know what percentage of people have presently used that device, but it's huge. So the numbers were significant. But my point for you is, for you to think about it, sometimes that's a really incredibly difficult thing to do. But you don't care what the judge says. You have a job to do on behalf of your client, regardless of the pressure you get from other sides. Because here's the problem. When you sell out that client for shorter money than they should have gotten, and then a month from now, 6 months from now, a year from now, they have buyer's remorse about the settlement, and people have buyer's remorse all the time. You have to be able to look the client in the eye and say, this is the very best possible deal that we could get, and this is an appropriate number. You can't defend yourself to the BBO, or you can't defend yourself to the man in the mirror by saying, well, that judge was a real bully and he would have really yelled at me more. That's what we get paid to do, right? We get paid to take that heat. And that's why I want to make sure you understand that your job at the end of the day, and I don't mean to do it unprofessionally or not civilly, is to push back, and especially as young lawyers, pushing back against the judge, saying no, insisting on your rights, your client's rights, is a very difficult thing to do, but that's our job. And I think you need to take that seriously and recognize it. You know, end of the trial, the judge says, okay, those are the instructions I'm given. Is everyone happy? And they say it like he's saying, you're happy, right? Don't say another word because I want to send this jury out. If that's not the instructions that were appropriate, or I still want you to give a couple more that you now say you won't give, I'm going to be an ass. And I'm going to say, no, Your Honor. I've told you all along, I thought instructions 31 and 33 were required to be given, and I think it's reversible error for you not to. And that's your job. Your job is to protect them and be their voice, and not to appease anyone, but especially to appease a judge. And because there are judges, and this is sort of old school, and he's retired, I think he's probably dead now, that pushing us to do things that they want us to do isn't always because they're motivated by a generous heart. It's because they want to be done, and they want you to help them facilitate that. At the end of the day, it's your name. You're the one signing the settlement agreement. You're the one that is going to have to defend it down the road. And it's sometimes it is difficult to do, but that's what we get paid to do. One more case, Valheim versus Braverman and Caskey. And I think that this is a very unusual situation. Usually, on behalf of clients, you are pushing the insurance company to settle, to make this thing go away, because if it does within policy limits, it doesn't cost me a dime. Great. My worry always is that if you take it to trial and lose, if there's an over policy verdict, that means I'm paying every dollar over the size of the insurance policy. So frankly, if I've got $1 million insurance policy and I'm the insured, I don't care if you give them $1 million. Doesn't cost me anything. And if you're saying, no, we think we can get out for $600,000. So you say $400. Okay, what happens if it's a $1.2 million judgment then? Well, you're going to still kick in your maximum of $1 million, but I'm out $200,000 now. So even when clients are insured like this, automobile accident cases, umbrella policies for their homeowners and the like, they need to understand that they may need a lawyer to work in pushing the insurance company to do the proper thing, comply with 176D. If liability is clear, make an offer. Make an offer up to the policy limits. But think about that. They don't have anything to lose over the policy limits. So to some extent, if it's a high demand and a high judgment, they figure, what the hell, we'll take it to trial. Maybe we can win and save all of that money or save some of it. But what they're doing under those circumstances is exposing you to an excess verdict. And that's why you need to interface with that insurance carrier and push them to make that reasonable settlement offer once liability has become reasonable clear. What this is an interesting case because it's a sex harassment discrimination case. They want to be done. They want to settle this case because they don't like the way this looks from a standpoint of liability or ultimate judgment. The plaintiff says, okay, I'll take that money, and I think it was a couple $100,000, $190,000, and I'll be gone. And insurance company says, you know what? That's a good deal for us. Plaintiff says that's a good deal for her. Defendant says, nope, I want my reputation cleared. I wanted to retract the charges, and I've got a counterclaim here, so you can't settle it over my objection, which is incredibly unusual, but I have seen, I want an apology, I want you to say that the charges weren't accurate, blah, blah, blah. Here, we take it to the next level, and he's looking for an injunction to prevent the insurance company from settling over his objection. As a general matter, the insurance company has the right to settle. The problem here is they can't settle when it would adversely affect the insured's rights. And this will because it'll eliminate the counterclaim. It's an unusual situation because what the defendant is saying is my rights will be prejudiced if you settle this over my objection. And so it's unusual that you have that counterclaim. It's unusual that the defendant doesn't want it settled. But under the circumstances, that it is problematic. But it's a rare situation that it's problematic, but it is. Defendants are right. They can't do this over the defendant's objections where it will affect their rights. As a general matter, it's a very unusual situation, because usually the defendant is pushing the insurance company to pay out every dollar of that insurance policy if that will mean we are done. I had that situation down in Rhode Island. I was a defendant in a case. One of my children were driving one of my cars down there, got into a pretty good accident. I got sued down there because the car was in my name, and we had a really good policy, and the damages weren't that significant. Problem was the plaintiff died she was like 90 years old at the start, died during the course of the litigation. I didn't care whether you gave her $500,000. I don't want to take the chance that some cockamamie jury in Rhode Island comes back with a $600,000 or $700,000 or $800,000 verdict. Not that, and the chance of liability was not zero, because it's never zero, but in the single digits. Chance of establishing damage is causally connected to it. Again, well, maybe I'll go 20%, okay? But not the full. She's gonna die shortly anyway. The problem is, I can't predict the future. I know you've got a $500,000 policy. I had to continually push the insurance company to try and settle that case within limits, and the limits, they didn't want to pay $5 because they knew it was a pretty relatively weak case, or guarantee me in writing that if they tried it, it was their risk on an excess judgment, in essence, to agree to indemnify me for any judgment over and above the policy limits. They don't have to, but if they're going to take the risk, of trying it over my objection, well, then you take the risk of the excess judgment, even because you're saying it's such a small chance. And we were able to negotiate that, and you can do that. And that's the point, is sometimes, again, you got to push back. That's our job. And insurance companies and judges and others, they don't listen. You gotta push. So there's a lot of litigation with insurance companies like this, because they litigate because they can win, or they've got lots of lawyers in-house to be able to defray that cost. I will see you next time.